Hello, my name's Jen. I've lived in Warren for about 30 years and I have no legal background. Quite a few people have already spoken much more eloquently than I can for the same reasons. But here I go anyway. Thanks for all you guys do for the larger cause of justice in our state and for this thoughtful public process, which allows for the presentation of the more specific concerns, which could have a bearing on how the judicial system serves us all as individuals. These testimonials and discussions should not be about who a candidate is outside of the courtroom. They're all clearly good people with successful careers, community connections, families, partners, all of those. And they've been willing to work the long hours required to have achieved so much. Everyone on the list of nominees is conversant with the law, has experience that could help them adjudicate cases before the court, and understands the unique role of a judge presiding over the district court. However, for candidates for whom there is a public paper trail, that information must be considered when evaluating their appropriateness for the role in Rhode Island District Court. Quite a few of the legal professionals that have spoken before have mentioned the interpretation of the spaces between the law. What I have learned tonight has made me glad that I am able to participate in this process. I'm here to oppose the nomination of Mr. Michael J. McCaffrey to the District Court. I believe that his judgeship would be impacted by the personal beliefs demonstrated by his previous record of service to Rhode Island. The District Court hears domestic cases, including cases of domestic abuse, landlord-tenant disputes, and individual property rights. The District Court hears thousands of cases annually, necessitating a fast pace and rapid delivery of judgments. The District Court is also known as the People's Court. There is no jury. Many cases are decided by summary judgments. Many cases are self-represented, which I learned tonight is called pro se. The legal facts of a case may be clear, however. In the District Court format, the interpretation of those facts can be contingent on personal beliefs. And in this way, outcomes may be at least partly determined by jurisprudence. Mr. McCaffrey's history of public service illustrates how his personal beliefs biased that public service. As a senator, as we've already heard, he opposed marriage equality and abortion rights. He rewrote the marriage equality bill with some of the most strident religious language in the country. As a judge, he may one day be able to interpret the legislation he wrote. His interpretation of the words he wrote might allow him to roll back protections for same-sex couples or the LGBTQ plus community. He was instrumental in blocking every bill to codify Roe v. Wade in Rhode Island for over a decade, as you also already heard. He also participated in nationwide efforts to challenge Roe v. Wade. Many speakers have addressed the importance of respecting the people before the court. How can a judge respect a person who is before the court who may have made life choices that they do not respect? Mr. McCaffrey will be in a position to rule on aspects of the law regarding reproductive rights, domestic disputes between same-sex couples, landlord-tenant arguments where the renter is a member of the LGBTQ plus community, among others. How can Rhode Islanders be sure that decisions will be based on the law rather than his documented personal and religious beliefs? Although plaintiffs and defendants have the option to appeal to the Rhode Island Superior Court, the significant costs involved in these filings and proceedings are likely to preclude petitioners from this opportunity. The mandate of the District Court is to balance the scales of justice equally between the powerful and the powerless. Our judiciary, particularly the People's Court, must be dedicated to protecting the legal rights of those with less political power due to their race, ethnicity, economic status, gender, or sexual orientation. The judgment in a case must not be based or prejudiced by presumed moral authority, and the nomination process should be independent of who the candidates know in the current or past administrations. Judges take an oath to be impartial in the application of the law. However, it is impossible for anyone to be truly impartial when their personal beliefs, evidenced so strongly by one's past service, may be at the core of a decision. Based on the research that I've looked into for some of the other candidates, you have so many excellent options that I know that it can be in good hands without Mr. McCaffrey being there. Thanks for being here so late, so that the voice of the people can be appropriately heard and the tenets of our democratic society upheld. And just quickly, it's really inspiring, I have to say, to see this many people trying to be dedicated to getting it right, and this many people feeling like they can talk to you during that process. So thanks for doing this.